Hi, my name is attorney Michael Goldstein. I'm a bankruptcy attorney and a consumer debt advocate, and I'm here today to talk to you about the question that a lot of us have been asking. Can I really get fired if I file bankruptcy? A lot of people, when they're filing bankruptcy or even contemplating it, have this fear that a coworker or their boss might find out that they filed bankruptcy and people are going to treat them differently. They could be fired. They could be transferred to another position. They could be treated in a hostile or an adverse manner. Well, I'm here to tell you first that not only is that very unlikely to happen, but it's actually unlawful. There is an there's actually a federal law that protects you if, in fact, you file bankruptcy or conduct any constitutional right where you cannot be discriminated against that. So, in terms of can I be fired or can someone treat me in a hostile manner for filing bankruptcy, the short answer to the question is no. And what we do is we look at Title 11, which is the bankruptcy code. Specifically, we look at Section 526, which prohibits an employer from discriminating against an employee or firing that employee for filing bankruptcy. Essentially, the law reads in relevant part that no private employer may terminate the employment of or discriminate with respect to employment against an individual who is or has been a debtor under this title, meaning the bankruptcy code, solely because the debtor has filed for bankruptcy. Now, I can tell you that there are certain cases that have come out. A lot of cases revolve around the banking industry. Cases where tellers have been moved away from the public. Cases where people who work in the bank and lending departments have been fired. Cases where a company has essentially said that they're fearful that perhaps someone who filed bankruptcy will give the company a bad name. Well, the federal courts have ruled on that, and they have said absolutely not. Under the circumstance where someone files a bankruptcy and a company terminates them solely because they filed that bankruptcy, they sought protection under Title 11, the bankruptcy court and the federal courts have ruled that that is discriminatory, it is unlawful, and that in fact you can seek damages. You could recover any of your lost wages from the date you were terminated until you receive subsequent employment. If you get another job and your job is making less money, you can get the difference in pay. You can seek emotional distress damages. You can seek your attorney fees, and you can even seek what's called punitive damages. Now, if you believe that you have been the victim of any sort of discrimination as a result of conducting some sort of protected activity, such as filing bankruptcy, the best thing to do is to contact an attorney in your area. For more information on this topic and other bankruptcy and consumer debt related matters, do check us out online at www.consumerdebtradio.com or give us a call at 781-595-3800. Again, this is attorney Michael Goldstein, and I look forward to talking to you again about consumer debt matters and bankruptcy related issues.